Have you ever been on a jury?
No, I've never been called.
I've been called. It is really an incredible experience, and I think, like most of our viewers, I'm not a lawyer. I rarely go to court, so to watch the whole process of of a trial is incredibly interesting to begin with.
And you find that people are really, how to put it, it's not that they're being frivolous like in maybe the O.J. Simpson thing.
Nobody's frivolous.
But I mean, they really want to do the right thing.
Yes, they really want to do the right thing, and they try so hard to be objective and to look at the things that you're focused on. And I'm thinking, to the jury trial that I was on, nobody ever told me about nullification.
No, and then that's a sad thing, because in 1895, in this country, there was a Supreme Court case. Evidently, somebody was advocating that the trial was, how to put it, not conducted properly, because the judge did not inform the jury that they had the right to nullify the law. And so they wanted the decision nullified. And in this case, back in 1895, it was the corporations against unions. And laws that said you couldn't go on strike they were being enforced. But when it got to a jury trial, the jury would not enforce it, because they thought that was wrong, that unions have a right to go on strike. So they were trying to prohibit people on the jury from knowing that they had a right to look at these kind of cases and say, we acquit. So, but the whole thing with the jury nullification is just so interesting, because it really goes, well, it goes back beyond the Magna Carta in 1215, but basically King John had basically say that the barons had the right to form a jury, and that they could rule on the law as passed by King John. Now, King John also appointed all, the judges and the sheriffs and all that. If they wanted to get ahead, they had to please King John.
Right.
So the whole government apparatus was geared to supporting the king.
The king had him in their pocket.
Yes.
Yeah.
So no one had a chance. But in this case, under the barons, then they could rule against the king, and then that was law. The king couldn't do anything about it. Well, then gradually this became the right of all citizens, to be on a jury. What was interesting was that 1670, William Penn had left the United States after forming the colony of Pennsylvania and went back to England. He's a Quaker and a minister, so he was going to preach at his church, but they'd locked it. They'd locked the doors so that the congregation couldn't get in. Yeah, nice, right?
Yeah, not.
Because they only allowed the Church of England back then.
Right.
And Quakerism wasn't part of the Church of England.
No.
So he went ahead and had a service outside. So they were violating the law in a number of different ways. First of all, they had an assembly outside, which was illegal. You couldn't have more than, I think, 5 people together in a group. And of course, it wasn't part of the Church of England, and of course they didn't have really free speech, and all these other things. So anyway, he was arrested, and the jury was instructed to to look at the facts and the law, and then to make their verdict. Well, they refused to convict him. Then 4 jurers were thrown in prison without food, water, toilet facilities or anything, and for up to, some of them up to, I think, 9 weeks, in order to force them to go ahead with the others on the jury and to find them guilty. Well, these people held out, and because they held out, the top court in England ruled that jurors could not be held accountable for their decisions. And freed them. So, that one thing gave us freedom of religion, it gave us freedom of speech, freedom of assembly, and again, it gave the juries the right to make a verdict without having to be punished. So, or fear of punishment. So, I mean, 4 things right there. I mean, it's just amazing what one jury did.
4 crucial things right there.
Yeah. And then the colonists used this all the time. And the British just hated it.
Good.
You know, because the juries would find people guilty of breaking, British law. So they kind of resorted to, after a while, admiralty courts. Well, in an admiralty court, there is no jury. And in fact, today you'll find when you're in court, you might want to ask if you're in an admiralty court or a common law court. Common law courts will have juries. An admiralty court, you won't be given all of your rights. And it is interesting when you read the Constitution of the United States, Amendment 7, it states that every person in the United States will be granted a jury trial for disputes of $20 or more. Can you believe that?
No.
$20.
Wow.
Well, yeah. So, and then it's also in the Sixth Amendment that again that you will have jury trials, and then within the body of the Constitution is also there. So it's there 3 times, and they put it there explicitly because people like Thomas Jefferson, was John Adams, and so forth, felt that government, even elections, you can't be sure that the people you elect are going to be really different. You can't be sure of anything really in government, and they wanted another power that could nullify law. So we have, of course, the House, the Senate, the executive branch, the judicial branch, and juries that can nullify law. And the jury was considered to be the last bastion of protection for the Constitution.
I don't think a lot of people realize that, Bob.
Well, government school textbooks are approved by government. Mm-hmm. And the people who approve them don't want that in there. They don't want people to know that they have this right. And they try to select people like that out. That started back in, the 1850. A lot of abolitionists were trying to, of course, free slaves.
Sure.
And they passed a law, the Fugitive Slave Act, I think in 1852, that said even in states where slavery is illegal, if a slave is caught, they're considered property, they had to be returned to the property owner. They couldn't be free. Well,
the juries said no.
The juries consistently did not go along with it, which caused slaves to be freed in some states.
Right.
But at that point, they began selecting out jurors who knew about this. And so they tried to make sure that the jury was unfamiliar with this right. And they do that today. And the judge won't tell you have the right anymore, of course, since 1895. So if you don't know it, then you're not going to exercise it.
Have you heard of this happening recently?